Good evening. I would like to welcome you to our webinar entitled, What is a Contract? Hosted by the City of Los Angeles' Department of Cannabis Regulation. My name is Ernesto Morales with the North Star Alliances team, and I will be your moderator for tonight's webinar. Before we get started, let's take a moment to review some housekeeping rules. Please note that this webinar is being recorded and can be viewed after the editing process on DCR's Learning Management System. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available to you during this session. However, you will be able to see and hear all the panelists. There's an open chat box where you can interact with one another for networking or comment on the information being provided. Please use caution when sharing personal information in a public forum and keep your questions focused on tonight's topic. Please ask questions. Ask questions about tonight's subject matter in the Q&A box. We will be gathering and responding to your questions throughout the presentation, and we will have a Q&A session where you will also get responses in the last 15 minutes of tonight's event. You are encouraged to utilize the Q&A box at the bottom pane of your Zoom screen. If you use the Q&A box for questions, everyone will be able to see the questions when they are answered. And finally, please note that the content presented tonight was not created by the Department of Cannabis Regulation or the City of Los Angeles and is for informational purposes only. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code, nor constitute legal advice. If you have specific questions outside of tonight's topic, please call 213-978-0738 during business hours, which are Monday through Thursday from 10 a.m. to 4 p.m. to speak to a DCR representative. Let's move on to tonight's presentation. I'm very pleased to introduce this evening's subject matter expert, Zachary A. Knox. He's the managing partner at the Knox and Ross Law Group and leads the cannabis practice group. Mr. Knox is considered an expert in this field and has spent over a decade advising and representing cannabis companies and entrepreneurs across California. In 2016, he was appointed to serve on the City of Oakland's Cannabis Regulatory Commission and continued to serve in that role through 2019, which included serving as the commission's vice chair. Mr. Knox and his firm have been the contract legal service providers for the City of Oakland's Cannabis Equity Program since its inception in 2017. The firm has since been contracted to serve equity programs in the cities of Fresno and San Francisco, as well as outside of the state of California. Without further ado, I'd like to welcome Zachary and ask him to begin his presentation.
Thank you, Ernesto. I'm thankful for that very gracious introduction you offered, and welcome, City of Los Angeles and your social equity program. I am so happy to be here with you again tonight, and looking forward to talking about contracting. As you might know, contracting is a very important part of building your organization and building your business in this cannabis industry. And so we're going to go through a handful of things tonight. We're going to talk about the basic elements that need to go into a contract. We're going to highlight some of the most common terms that you will see in agreements. And time permitting, we're going to do a deeper dive into probably one of the most important contracting situations that you will find yourselves in, and that is the agreements that provide for the governance and oversight of your organization. So with that, let's start talking about contracts. And I'm going to go quick here. There's a lot of material to cover tonight, but please get your questions in. We're more than happy to answer them. So what is a contract? Well, a contract is an agreement or a promise to either do something or to not do something. But the key element here is that that agreement is going to be enforceable by legal action. That's what you need to take away. A contract is an agreement to do or not to do something that is legally enforceable. Right? You can think of it as oftentimes as an exchange of promises. I will promise to do A if you, the other party, promises to do B. And although we may not have done the actual conduct that we're promising to do, the very promise that we will engage in that conduct is enforceable with legal action. So that's what the contract is. It's an agreement, oftentimes for an exchange of promises to do or not to do something that is enforceable by legal action, right? Another important element of contracts is the consideration, right? We just talked about a contract might be an exchange of promises. And why would somebody be willing to obligate themselves in exchange for another person's promise? Well, the idea is that I place some value on that promise. That is the value proposition. Whatever I'm going to do, I'm willing to do in exchange for something that I value. And that value may come in the form of a promise from the other party. So that value exchange is what creates the consideration for the agreement. And without that consideration, the agreement may not be enforceable. So it's important to understand that the exchange has to have value for the agreement to be a contract and to be legally enforceable. All right. So what are some of the common scenarios where we see this? Well, when you buy goods, if you buy goods wholesale, as you often will in this business, it may be an exchange of promises. Distributor, if you deliver X amount of product to my retail store, I promise that I will pay you on delivery, or I will pay you on net 30 terms. That promise to pay is the consideration that I'm offering to the distributor to incentivize them to bring me the goods that I'm looking for. So again, that's an example of the consideration, and consideration or that value exchange must be there to make a contract binding. So again, consideration is the something of value that we're exchanging for. Also, in order to form a contract, there must be an offer. Somebody must offer something to an offeree, and that offeree must then accept. So now we're looking at an agreement sort of from one side. There's an offeror who is making an offer to an offeree, and that offer must be accepted. So if you think about this as you walk into a retail store, you might see a loaf of bread, and the sign might say that loaf of bread costs $2. You can consider that little tag, that price tag, to be the offer. And if you take that loaf of bread up to the register, right, they are offering that bread for $2. If you agree to pay that $2, they're going to let you walk out the store with the bread. That is the offer and acceptance. There must be an offer, there must be acceptance, there must be consideration for it, and those are essential elements to making a binding contract. So some examples of what might be considered offer and acceptance, and this is important to think about. The distributor offers inventory or a price list to retailers. And oftentimes you might think of that as being the offer that the retailer acts upon, like in the example I just gave. But you could also look at it as another in the reverse, right? When the retailer actually issues the purchase order to the distributor, that can be an offer as well. Right, so the retailer is offering to the distributor, I will buy X amount of product if you agree to sell it to me at this price. And that's what oftentimes what a purchase order is. then the distributor has to decide whether or not they're going to accept that purchase order and deliver the goods to the retailer. So there's a couple of different ways that you can look at offer and acceptance, but the important piece is that offer and acceptance is an essential element to any agreement and therefore any contract. It must be there for it to be legally enforceable. So oftentimes, we'll get the question is, does a contract have to be signed? And the technical answer is no, a contract does not necessarily have to be a signed document. Oftentimes it is, but the essential question there is, was there an expression of an offer and was there an acceptance? Because a verbal agreement can be enforceable if it meets all these different elements that we're talking about tonight. All right. So let's talk about some of the important contract clauses and provisions that you will commonly see as you come across contracts in this industry. Most agreements are still in writing. That's a good thing. It's the most prevalent form of contracting. But as I just said, it is not the only way an agreement can be established. That being said, it is by far the best way to approach entering into contracts is through written agreements. When you see written agreements, and what you see on this slide here is some of the most common provisions that you will come across in contracting. The recitals, an exchange and consideration. We've talked about that some already, the term, in some situations, closing, representations and warranties, how the contract can be terminated, what governing law applies. In this industry in particular, we'll need federal waivers. We'll talk about that more later. How do we resolve disputes? Severability, notice, waiver. How do we assign and modify contracts, entire agreement, and counterparts? These are common elements. We won't have time to get into all of them tonight, but we're going to highlight some of the most important ones. Let's talk about the recitals. This is often the beginning of a contract, and they're more of an introduction. They're not typically considered to be terms of an agreement and are usually not found to be the binding part of a contract, but nevertheless, they're important because they provide context to what the contract is about. And depending on the relationship that's being papered up with that contract, that context may be really critical and important to understanding the terms of the contract and why the contract was agreed to in the way it was agreed to. All right, so here are some, this is an example of what a recital might sound like in an agreement. Right, they have these clunky words that we use in my profession, like whereas and now therefore. And as you can see here, whereas the company has substantial expertise in consulting and providing management and consulting services to companies in connection with cannabis, right? So this was taken from a management services agreement where the management servicing company was establishing its credibility and its expertise in the recitals of the agreement. Now, that's not a binding part of the agreement, although you may want to rely on these representations here, and that'll be an important concept when we circle back to representations and warranties that might be made in the contract. But again, this is important context to understanding why a party might enter into a contract. And oftentimes that's what you'll find in the recitals. The next important piece is the exchange. We talked about this when we talked about the critical elements of a contract, that there be offer and acceptance and an exchange of value. There has to be an exchange spelled out in the contract. And the contract might be for goods, it might be for services, it might be for an investment or an employment or anything else under the sun, but it's an exchange of something, right? And that has to be in the contract. Now, as you come across these exchange provisions, and they might be worded differently, as I said, it might be a purchase agreement for goods, or it might be a professional services agreement and somebody's supposed to provide you services. So the exact naming of the clause may vary depending on the relationship, but there will be something there that we can identify as an exchange. And you want to ensure that that provision providing for the exchange specifies exactly what you expect to receive. If you are contracting for somebody to come in and do your bookkeeping, you don't just say, come do the bookkeeping. It may be that you're going to show up to my store, once a week, twice a week. You're going to reconcile against the banks once a month, every quarter. That exchange must be specified, and it might be in the body of the agreement itself. It might be called out in a separate exhibit, but as you review your contracts, when you identify those exchange provisions, the important part is that it needs to say exactly what you expect to get. Otherwise, there's more work to do in drafting. To that end, certain contracts should have specific deliverables or milestones. This is less of an issue if we're talking about a contract for goods, because typically that's really easy to wrap your mind around. I'm going to buy X amount of product and I expect that product to arrive in those quantities. It could be a little bit more subjective when it comes to something like professional services. And so in that exchange, you may want to identify specific objectives or milestones that you expect that contracted party to reach or achieve, and we call those deliverables. As I said, these may show up in the body of the agreement, but oftentimes they may show up in an attachment as well, say a schedule of deliverables or scope of work. So every once in a while, when we do consults, we'll get folks coming into our office with a contract that they were presented, and they leave out the schedules and the attachments. And you have to look at these comprehensively, because certain things may be broken outside of the body of the contract itself. We talked about consideration, and consideration being the value that's being exchanged for to create a binding agreement. 90% of the time or more often than not, the consideration is a form of payment, right? Most people want to be paid cash for the goods and services they provide. And so in most common experience, the consideration is the payment. So you can imagine that in a contract, you're going to want to make sure that whatever is being paid, the language around that is specific about how much that payment is supposed to be, how that payment is going to be structured, whether it's going to be broken up into payment methods, installments, whether discounts are going to apply, the timing around when those payments should be made. You want to make sure that all of that is laid out in the agreement. Okay, the term of a contract. The term is a period of time during which the contract is effective, or when parties are expected to fulfill their obligations, right? So, for example, you may have hired your CEO, or actually a better example would be your lease. When you sign a real estate lease, everybody here, if you're going to open up a licensed business, has to sign a real estate lease unless you own the property outright. Every single one of those leases will provide for a term. And in that case, that is the period of time for when the contract is effective, when your lease is effective. And it's often temporally bound, right? It's a period of time. Sticking with the lease as an example, terms can also come with renewal clauses, or they may provide an option to extend. And these are provisions in the contract that allows one or both of the parties to agree to extend the term for a longer period of time. So since we're talking about this in the context of real estate, I think it's really important to point out that for each of you, negotiating for a tenant option to extend is highly recommended. Oftentimes you are investing a considerable amount of money to improve these spaces. That investment in those improvements becomes the property of the landlord. It is beneficial for your business if you can negotiate as much time as possible to take advantage and benefit from use of that licensed space and those improvements that you've invested in. So whether you're talking about a 5-year term with 5-year options thereafter, or a 10-year term with 5-year options thereafter, it is really important to push for those in your real estate leases. They are going to bring tremendous value to your business, having the ability to extend the term at current rental rates or whatever the agreed rental rates are, instead of having to go back out to the open market in the future. All right, closings. Closing clauses are something that you will often find in investment agreements. And basically the closing is the process of confirming that all the obligations and all the requirements in a contract has been met. And in these closing provisions, you will often see reference to a closing date. You can think of that as a deadline for when everybody has to have completed their tasks and their obligations under the agreement. I bring this up, as I said, and it often comes up in the context of investment deals, because usually an investor wants to spend a certain amount of time betting your business and doing their due diligence review. And again, you don't want to be on the hook for forever, catering to somebody who might or might not put some investment into your business. So these closing provisions sort of create a stopgap on that. If by the deadline, not everybody's satisfied and we can't deliver on all our obligations, then the agreement falls apart. If everybody can perform by the closing date and the parties are able to close, then everything proceeds forward. And so that's the most common situation where it'll come up in this industry, but be on the lookout for closing provisions, particularly in those investment deals. Related to closing and closing provisions, we need to talk about closing conditions. And this is typically what spells out the obligations that each party must perform under the agreement. And oftentimes it comes in the form of the checklist. So for us to close, you need to deliver document A, B, and C. And the other party may need to put a certain amount of money into escrow, and that's their obligation. But the bottom line is those closing conditions are what specifies all the little attenuated details that everybody needs to take care of for a deal to come full circle and close. All right. Next is representations and warranties. The representations and warranties establish the trust and confidence that each party needs in the other to proceed with a contract. Earlier, when we were going through the recitals, we talked about some of the representations that were made there to give context to a contract. But I also said that those recitals are not binding. The representations and warranties are. And oftentimes a misrepresentation or a breach of a warranty constitutes a material breach of a contract that could potentially unwind a contract, and at the very least create some liability between the parties. Why is this critical? Because the parties need to be able to rely on these representations and warranties. Right, some of the most basic representations and warranties that you will see in almost every contract is due authorization. Due authorization is you're essentially stating as the signatory of the contract that you have the authority to sign the contract. And if you sign the contract when you did not have the authority to do so, that is a material misrepresentation and could be used to void or break the contract. Right? So here are some other common representations and warranties that you would expect to see in many contracts. One, that your business exists and is in good standing with the state. If your business is not in good standing with the state, technically you do not have the authority to operate. So the other party will often insist that you represent that you are in good standing, right? And that you have the authority to execute the contract, as we discussed, that you are operating in compliance with laws and regulations. That's an important one for this industry. That you've made all government filings and obtained all consents needed. That's also very critical in the cannabis space. And that you can actually perform your own obligations under the contract. These are common representations and warranties. Another one that is very unique to just this industry, though, is that you are maintaining a valid operating permit, right? This is important. This is an important representation for you to make to give your business partners confidence in your business. And if you are contracting with other strategic partners, whether they're suppliers, you're going to want them to represent that they have a valid operating permit as well. All right, another important provision in contracts is the governing law and venue. Contracts disputes arise all the time, as it says here. If you're in business long enough or you're successful, it's not a matter of if, it's a matter of when. And so you need to define a process to resolve disputes. And the first step in that is deciding what law is actually going to apply to our contract. Now, everybody in this room is probably going to be an operator here in California. So I'll make this easy for you. Your governing law should be California law. Even if you have vendors from outside the state, if there's an opportunity to push for it, you should be operating under California law, and that should be the law that applies to your contracts. You also need to think about venue. We're doing this webinar for the Social Equity Program in Los Angeles, and you will all likely be opening up your businesses in Los Angeles. You don't want to have to travel all the way up to Wairika to settle a dispute with one of your suppliers up there. It may be important for you to spell out where you want your dispute to be resolved. And let me go ahead and make this one easy for everyone too. It should be the city of LA or LA County at worst, at most, as the appropriate venue, right? You want to defend yourself. You want to resolve disputes in your backyard. You don't want to have to travel for that. Federal law and waiver. These are very important in this industry, right? Particularly if you're dealing with out-of-state vendors, where if there is a dispute and it gets into court, they can have it removed to the federal court. And if it's removed to the federal court, good luck on enforcing your rights as an unlawful business. So one of the things that you will commonly find in contracts or for cannabis with cannabis businesses, and you should probably insist upon it yourself, is that there is some waiver of federal law, particularly as a defense to the validity of the contract. The goal here is to preempt any potential excuses to change the venue and to change the governing law that the contract is being interpreted with. As I said, the last thing you want is for a dispute to land in federal court and have federal law govern how that dispute is resolved. So the federal waiver is very important in this industry. Make sure it's in each of your contracts. I can't stress enough how important that is. So what you see on the screen now, and you'll have to forgive us, it's cut off a little bit, but this is an example of what a federal waiver might look like, right? There's an acknowledgement here that the state has passed amendments to its constitution and has enacted legislation authorizing and governing the cannabis industry. There's an acknowledgement that this still is illegal at the federal level if federal law applies. And then each party is voluntarily and unconditionally waiving any right of removal or appeal to federal court. So that's sort of what these provisions will look like. You want something to this effect in the vast majority of your agreements. All right. Dispute resolution is another important piece of this. We talked about venue, we talked about federal waiver, we talked about governing law, but there's advantages to not showing up in court in the first place, right? And courts tend to favor parties resolving their disputes out of court, right? So therefore, most contracts will provide for what we call alternative dispute resolution, what people commonly think of as mediation, arbitration, or some combination of the two. These can streamline your dispute resolution process. If you're looking to litigate in court, you probably will not have a court date within 12 to 24 months. If you're going the mediation or arbitration route, you might be able to get it done in 3 to 6 months. It'll save your business a lot of money. This is by far the most common way contracts are drafted nowadays to include these sort of dispute resolution mechanisms. As I said, we call this ADR, and they're intended to help avoid costly, time-consuming court battles. So what you're seeing on the screen now is some sample language of a mandatory arbitration provision. What it provides for is that all claims, disputes, controversies, and disagreements will be subject of binding arbitration and mandatory arbitration, right? So this clause, for example, just sort of gets to the heart of it. We're going to address all disputes with arbitration. All right, liquidation damages and limitations of liability is another clause that can be used to prevent extended court battles and catastrophic losses for that matter. So a liquidated damages provision, what is that? It is a specific dollar amount tied to damages should a party fail to meet their obligations, right? So you may see this if any of you had satellite TV, right? And you wanted to cancel your subscription and you didn't do it right, and they still come after you for the $400. Chances are there's a liquidated damages clause in one of their agreements somewhere. It's sort of a way of fixing what the liability is for certain breaches of contracts. And that can cut both ways, right? But it provides a certain level of a certainty that can operate to keep people out of court if they know what the cost is going to be. All right. So here's a sample of a liquidated damages clause. Party B acknowledges that delayed in their performance will damage the other party, and as such, if the performance is delayed, the other party will get, $500 a day or something like that. So that's an example of how liquidated damages might show up in a contract. A limitation of liability is another way to approach this. It sort of creates a cap on the amount that can be claimed in any sort of breach of contract. And what you may realize is that there's certain caps, that might de-incentivize certain types of legal action and incentivize the other types. So it's sort of, once again, like liquidated damages, creates some certainty around where a dispute could go and how it could operate. And that the effect of that can be to keep a lot of claims outside of court and resolved through some other mechanism. So here's some sample language of what a limitation of liability clause might look like. And what it says here is that, to the maximum extent permitted by law. No licensor or supplier should be liable for any special, incidental, direct, or consequential damages, loss of profits. So they're essentially waiving all these sorts of damages that could be claimed for in the litigation. What it does instead is it sets a cap for how you're going to calculate damages in this context. Right. Indemnification. Many contracts contemplate that claims may be brought by third parties. And if the third party claim is brought, who's responsible for dealing with that in a contract? And oftentimes these indemnification provisions can be used to protect one party from problems created by another party that impacts a third party. I know there was a lot of parties in there, but the bottom line is that if you're contracting with somebody and in the scope of their work, they may create third-party liability for you, it's going to be important that you have one of these indemnification clauses in your agreement protecting your business. And so here's an example of what an indemnification clause may look like. And I should point out that this one has mutuality to it, meaning each party is indemnifying the other party for any claims or liabilities that may occur or accrue on the conduct of that party. So these are also very important provisions defined in contracts. Make sure that your indemnification provision includes everybody who's associated in your business, your directors, your officers, your managers, your advisors, your employees, your contractors, your volunteers, right? You want it to be comprehensive so that you can maximize your protection, right? So as you can see, what we have highlighted here is sort of a broad-based approach to creating a set of indemnified parties for your business, right? You need to also spell out the broad range of potential liabilities that you may want to seek indemnification from. And as you can see in this sample language, you want to be held harmless from and against any all claims, judgments, damages, liabilities, settlements, losses, costs, and expenses, including, most importantly, those attorney's fees. They're all defined here as a loss, and you're being indemnified from those losses. Very important to be included in your contracts. Severability is very basic. Oftentimes, if there is a dispute and a contract is being interpreted by a court, they may decide that some part of it is not enforceable. And it used to be that if a court deemed some part of a contract was not enforceable, then the entire contract would not be enforceable. Hence the creation of these severability clauses. And the purpose of these clauses is to keep the rest of the contract enforceable, even if part of the contract was adjudicated to be unenforceable. So that one bad clause or one bad provision in the contract doesn't void out the remainder of the contract, right? So here's an example of what a severability clause may look like. And as you can see, it makes really clear that, if any part of the contract is held to be void, it doesn't impact the remaining portions of the contract. Waiver clauses are also common in contracts. And these are a little counterintuitive because they're called waiver clauses, but they really mean that no waiver has been made. And the context that this comes up in is it used to be that if you didn't enforce your rights under an agreement, that those rights could be deemed to be waived. Think about this, going back to the real estate context. If the landlord failed to enforce your payment of rent, that would operate to waive his right to collect rent. it's kind of funny to think about it in that context, but it's that exact situation that led to the development of these waiver clauses, or sort of a non-waiver clause. And the way they're often written is that if one party, failed to enforce or demand exact letter of the law compliance with the contract, that does not operate as a waiver of any enforceable right they may have under the contract. That they can still enforce those rights later, even if they didn't do so in one case or another. So with that, let's dive in for the last few minutes into some of the most important pieces of one of the earliest contracting situations you will find yourself in. And that is providing for the governance and structure of your organization. Right. And so there's a handful of things that we're going to want to burn through here quickly. As you formalize your business structure and as you start executing governing documents, whether that's an operating agreement for an LLC or a shareholder or partnership agreement, or even establishing corporate bylaws, there's some things that you're going to want to think about here. Provisions around capital contributions, distribution rights, management participation, and buy-sell provisions. I'm going to get through these as quickly as we can. So the capital contributions, these are the assets that members or owners of a business put forward to finance the company. Traditionally, their investment in the company is proportional to their ownership stake, right? So if a business needs $1 million to get off the ground and it has a $10 million valuation, and somebody puts up half of that $1 million, they would typically expect to receive half the equity, right? This is where social equity sort of flips things on its head, right? Equity licensees may require that the qualified partner hold 51% of the business, regardless of the capital that comes in. And without adequate resources, the partner must secure capital in their environment where they're limited to selling only 49% of the business. And so some of the challenges this creates is that the equity partner gets 51% of the business, and in the mind of the investor, they haven't contributed anything. The investor has put up all the capital, right? So it's this perception of the disparity in the financial obligation that drives a lot of questionable and predatory behavior that we're on the lookout for. This is why we've scrutinized these capital contribution provisions and language, right? And, just to be obvious, state the obvious, is predatory behavior often comes from the proposed capital partners that you may be dealing with. So what does this might look like in your agreement? They might ask for future capital calls. These are demands that the owners be willing to contribute more money. And for equity qualified partners who are under-resourced by definition, these future capital call provisions have been used to squeeze out equity partners. Okay. So here's a sample of what some of these provisions may look like, right? There's an additional capital call provision here. This was taken from a real agreement that was presented to an equity applicant. And then there's language here about what happens if that member fails to make a capital call, right? And in this particular case, what this ended up happening was the consequence of not being able to meet that future capital call. The equity applicant had their voting rights impugned, and they had their right to distributions limited and or reduced. And it was really a way that at any time the manager could make an equity call and force the equity qualified partner into this very difficult position. So these are some of the things that we'd be looking for in these capital contribution provisions. So again, to the point I was making, the difference in perception around the value being contributed has been used to justify a reduction of influence and voting power of equity partners, or forcing equity partners to enter into separate agreements that may favor the capital partner, for example, management agreement. Speaking of management, let's talk about your participation in the management of your own business. This is often a subject of the operating agreement or the shareholder agreement, if not a direct employment agreement that you may have, right? You need to understand the role you will play as an owner and at other levels of the business, right? We're going to focus on ownership and board levels here tonight, as the most critical levels in some of these governing documents, and important for you to think about as you find yourself in this very early contracting situation. As an equity holder, as an owner, you should participate in management at the ownership level. You should be electing board members if it's a corporation, managers if it's an LLC. You should have the opportunity to vote if there's going to be any new ownership interest issued. And for certain major transactions, whether you're going to sell the business, close the business, merge with another business, you as an owner should have a vote in every one of these things, and that needs to be provided for. Be wary of any contract clause that would limit your right, such as allocating you shares that might have lesser voting power or no voting power, right? So here's an example of what some predatory language may look like. The Class A common stock held by the capital partner gets 10 votes per share. The Class B common stock held by the social equity partner has 1 vote per share. This is one of the ways that they may try to gain some leverage over you in this contracting scenario. If you're a corporation, a board is required. If you're a manager-managed LLC, the manager sort of serves in the same role as a board of directors for a corporation, right? And that role is to oversee the business at a high level and delegate operational authority to executives and officers that are going to be doing the day-to-day. You may find that you're wearing many of those hats, right? But you have to think about your obligations at different levels of management because the responsibilities are going to be different. As I said, LLCs, instead of a board of directors, have a manager, sometimes even a board of managers, and they sort of fill in the same role as the board of directors in a corporation. This is often the most significant level of management, right? You need to review your role at this layer in the organizational structure, as it can be extremely consequential. Owners with any significant ownership often maintain direct representation at the board manager level. You should too. This is accomplished through voting rights. It can be accomplished through appointment power, but you need the ability to have yourself or your representative involved here. That's an important part of that governing contract, that governing document, right? Be wary of these sorts of clauses in regard to your management participation, whether it's only receiving observation rights or if they're forcing you to serve individually as opposed to allowing you to appoint somebody to represent you who may be knowledgeable and experienced in this area, or allocating voting power that is significantly disproportionate with your ownership. So for example, if you're a 51% owner, but they're trying to only give you a 10% vote, that would be significantly disproportionate, right? Distribution rights, right? Your right to distributions is your right to get paid as an owner. You need to closely examine these clauses, because another place where predators try to get you is tinkering with the distribution rights or allocating themselves certain preferences. Distributions and dividends, as I said, are how owners get paid. This is in your capacity as an owner, not in your capacity as an employee of the business. So if you are the CEO of the business in addition to being an owner, you have an employment relationship with the business and you have an ownership relationship with the business. As an owner, you may receive distributions and dividends. As a CEO or some other sort of officer, chances are you should be getting a salary. Right? These are typically paid out in proportion to your percentage interest in the company, but capital partners may insist on preferential treatment. And that's common in a lot of industries where they may insist on certain preferences. So let me dispel one thing right now. Not all preferences are going to be predatory. They're not all necessarily predatory. The question is the preference reasonable? Right? It may be justified if it's reasonable, right? So for example, if I'm putting up all the capital in the business, and I said, okay, well, until I recoup my investment, let's say that we're going to take half of the distributable cash and contribute that towards return on investment. And then the other half. I mean, that might be a reasonable split. What wouldn't be a reasonable split, in my opinion, where the capital partner wants all the distributions until they fully recoup, and leave the equity partner holding the bag and waiting. So the real question here is that disproportionality justified and reasonable, right? And so how do you evaluate that? Well, how much are they investing? Is it debt investment? Is it equity investment? Do they have other valuable resources beyond just cash? Are they bringing the real estate? Are they bringing the product? How disproportionate is the preference? And most importantly, will the preference ever sunset? Does it ever expire? Those are questions to ask yourself as you read these provisions and determine whether it's reasonable. As I said, be aware of any suspect clauses, such as requiring 100% return on distribution before the equity partner gets anything, or if there is a hard cap on how much an equity partner can earn. Okay, buy-sell provisions. This is the last section. What happens when there's an irreconcilable disagreement between owners? If you've gone to mediation, if you've gone to arbitration, you can't work it out, and it's just going to be disagreement from there on out, one party may need to exit, right? Those exits can be very messy. So oftentimes we will recommend that you build some sort of exit mechanism into the agreement. And in the case of partners or owners in governance in their business, that comes in the form of a buy-sell provision and or a liquidation preference. The buy-sell provision outlines the terms under which one owner can buy out another, real simple. And the liquidation preferences specifies how assets will be allocated in the event of a dissolution, if the business needs to be wound down. Again, a lot of the fight in these situations, if you don't have a buy-sell provision or a liquidation preference, is around, well, how do we value it? How do we split this up evenly? And these provisions can contemplate some of these scenarios in advance and provide that framework so that we don't have to fight about it later, right? But that being said, these same provisions could also be used as predatory language in an agreement, right? So, beware of provisions and preferences that place a hard cap on the price of a buyout, or places a cap on how much you can participate in a liquidation. What we like to see, particularly on buyouts, is that you're being bought out for value, right? The fair market value of your interest. And you can put in mechanisms in place to determine what that is in advance without having to come up with a number. And the same thing on participation. You want to make sure that you have a reasonable opportunity to participate. And so here's some sample language that would be predatory, right? and what you may not see here fully because it's partially cut off, is that in this scenario, the on a liquidation, the equity partner was going to be capped, I believe, at $120,000 for their interest in of their equity in the liquidation. And this was for a store. And so you can imagine this store that's probably worth, you know, $5, $7, $8 million, and 51% of it could be sold off for 120,000. Right, that's a predatory preference there, a predatory cap. Right, so that's it for the presentation. Those are the things I want you to be on the lookout for in your governing documents. We talked about some of the common clauses that you will see in most contracting scenarios, and we talked about how to establish the contract. If you have any more questions, you can contact the DCR. And you can also contact the LA County Bar Association if you have any additional legal questions through their pro bono and low bono program. And I'm happy to take the rest of the time to answer any questions, Ernesto. You're on mute, Ernesto.
Let me unmute myself. There you go. Thank you, Zachary. That was so much good information in such a short period of time. That was, you know, a lot of really important information and very concise. Let's move over to the question and answer portion. I know that we will have a lot of good questions, and I want to go ahead and start off with a few here. Tell us what breach of contract is and what should someone do if a breach occurs?
Yeah, so very important. A breach of contract is what we call when somebody either expressly violates the contract or fails to perform their obligation under the contract. If the breach is material enough, as I said in the presentation, it could be grounds to void or terminate the contract. That being said, I wouldn't rely as a layperson on my own judgment to determine whether a contract has been breached. If you believe that your contract has been breached, my suggestion is to contact legal counsel as quickly as possible and get a fair determination on that.
Okay, that's great information. Let's go to this one. What if I sign an agreement without reading it? Is the contract still enforceable? I know there's people that do that. I don't believe that still happens in this day and age, but what if I don't read it? Is it still enforceable?
It happens more often than you think. And in general, and I'll say this, yes, it's enforceable. If you're of age and you had the opportunity to read it and had the opportunity to consider, and you signed it anyway, and you just didn't, it's going to be enforceable against you.
Okay, wow. We have a question from Denise, and let me make sure I'm reading this right. Can an LLP, a two-partner situation, without written notice or knowledge, be removed from the LLP? Does that make sense? So I think basically, yeah, if it's two partners, I think the question is if one of them can be removed from the partnership without written notice or knowledge.
Yeah, so I'm gonna parse this a little bit because I think she may have meant LLC.
Okay.
An LLP is a limited liability partnership. It is a partnership, even if it has limited liability affixed to it. It's often used for professional partnerships like law firms. And as a partnership, if it's a two-person partnership, one person walking away does breach the partnership. And I think what's different in an LLC, for example, is oftentimes there is no ability to voluntarily withdraw, right? And so the reason behind that is that when you get into partnerships with people, you know, you don't want them jumping ship just because they think the grass is greener somewhere else and then turn around and ask for all their money back because they got cold feet or something like that. You want people locked in. You want people that that you can work with. And so oftentimes in an LLC operating agreement, you'll see a provision that says no voluntary withdrawal. For Denise's question, though, if she is in an LLC or had this experience or knows someone who had this experience, the first thing they need to do is go back and check their operating agreement and see what rights are provided for in terms of voluntary exits from the business, involuntary exits if you have to force somebody out, because in general, there is no ability to just force someone out. And there may not be an ability for you to voluntarily walk away without creating some liability. So the first thing to do is to check your operating agreement. But it's going to be highly dependent on them.
Yeah. Good information. All right, let's talk about mistakes. I know you don't make any, Zachary, but let's talk about mistakes. If there's a mistake in the contract, does that affect its enforceability?
Yeah, it can. And this is a great question. And like all great questions, the answer is it depends.
Depends.
So there's a concept in the law of unilateral mistake and mutual mistake. So Ernesto, if you and I were to enter into an agreement and the agreement in my mind was based on the sky being purple, right? That's my unilateral mistake. The sky is not purple. The sky is blue. Anybody can look up and see the sky is blue. But if I got into the agreement on the belief that the sky is purple, that is my unilateral mistake, right? That agreement's still going to be enforceable against me. The difference is if it's a mutual mistake. So if you and I agree that there's some fact out there that's the basis for our agreement, and it turns out we were both mistaken, then it may be that contract is not enforceable. So it's highly fact dependent, but that's why it depends is the answer.
All right, that makes perfect sense. And I think this goes along the same lines, right? We talk about contracts and the importance of, getting everything in writing, right? Why is it a good idea to get everything in writing?
Oh, that's a great one. There's a lot of good answers for why. There's a lot of rationale for why you want it in writing. Number one, if it's in writing and there's a breach, the statute of limitations for you to bring a claim is 4 years. If it's not in writing, you got to bring that claim within 2 years. The other thing, when you're trying to enforce an agreement, it is much more difficult if you find yourself in a he said, she said situation. Because invariably, once the agreement has broken down and the parties are fighting and they're going to court, nobody's going to acknowledge anything that's not favorable to their position. So you want it written down, you want it signed, even better, because that sets into concrete, that creates indisputability around what the terms of the agreement are. And so that becomes much easier to enforce later. And I'd go as far as to say, this is the reason why in the presentation I was harping on, you want to make sure that the exchange describes with specificity what you're going to get. And specificity around what the consideration will be. We often draft contracts for clients, and some of the questions I often get is, why does it have to be so long? Or why does the language have to read this way? And what we're trying to do is drill down and be very specific with the terms so that there is not room for interpretation. And if I can leave you with any impression on this particular question, is that more room for interpretation means more room for argument, more room for disagreement, and more litigation. We call it full employment for attorneys.
There you go. And I wouldn't say that you were harping, Zachary. I would say you're reinforcing.
There you go.
We wouldn't say that it was heartbeat. So, that brings up a good point. When we're talking about all these different variables, all these different components, when you're putting together a contract, what would constitute an offer, to really make sure that we understand that?
Yeah, so an offer oftentimes is a matter of perspective. That's why I brought up the example of the purchase order and the distributor with their sales list, right? Which one constitutes the offer? And it can oftentimes be a matter of perspective. I think when you look at trying to identify where the offer is, you have to fixate on what expression is being made that invites consideration, right? So it's always an exchange. Somebody is going to do something in exchange for something else. I think it's sort of easy in the context where it's cash changing hands for
Right.
goods and services. That's easy to understand. But if it's an exchange of services, for an example, right? Who's making the offer and where is the acceptance? And so it really comes down to who made what expression and what did the other party understand. Again, another reason to have it written down in a contract, right? That makes it a lot easier.
Sure. So I'm gonna flip it. So what constitutes or what is a counteroffer?
Okay, great question. A counteroffer is a form of rejection, actually, of the original offer. So if you think about this, an offer was made and you can accept, or you can reject, or you can counter. And that counter is a rejection of the original offer. That goes away. You can no longer hold the original offeror to that when you've made a counter, but it's a counter proposal of alternative terms or an alternative deal arrangement that you would be willing to accept. And so where you had the opportunity to accept the original offer or reject, your counter flips it around and that becomes your counter offer, and the original offeror now has an opportunity to accept.
Good stuff. Good stuff. And I'm going to talk about offering a little bit more. Can an offer be withdrawn without incurring liability to the other party? I'm going to come full circle here, Zachary. You knew it was coming.
We're on a roll. So an offer can be withdrawn at any time prior to acceptance. But the minute that acceptance has been expressed, you can no longer withdraw the offer without there being some sort of liability.
Well, Zachary, I want to say a big thank you on behalf of everyone that listened in today, that everyone that's going to download this, a wealth of information, and really appreciate your time and all the good information, the offers, the counter offers, the consideration, the promises. I took notes. I definitely did. But thank you so much. And I want to say thank you to everyone for attending this very informative webinar offered by the City of Los Angeles Department of Cannabis Regulation. This webinar recording will be found on DCR's learning management system within a few weeks of this presentation. If you have any questions on accessing your account, please email dcr.sep@lacity.org. Thank you again for joining us and have a fantastic evening.